California meal and lunch break law is complicated. This video will make it simple. Stick around because I'm going to explain everything that California employees need to know about meal breaks. We're first going to review California's basic law regarding meal breaks at the workplace. Secondly, we'll review the common violations that employment lawyers like me see day in and day out. And finally, we're going to review the monetary penalties that employees are owed if their employer forces them to miss their lunch breaks. The basic tenets of California meal break law are here. Basically, if you have a shift that's longer than 5 hours, you're entitled to 1 meal break. If you have a shift that's longer than 10 hours, you're entitled to 2 meal breaks during that workday. And that meal break must be at least 30 minutes long. Some employers schedule longer meal breaks. Some employees can have the ability to choose to take a longer meal break, but at a minimum, that lunch break must be 30 minutes long. And it must be, as lawyers like to say, uninterrupted, meaning you're not doing any job duties at any point in time in that lunch break. So it must be uninterrupted. Now, this meal break must be unpaid, meaning you are off the clock. You clock out, you're gone for 30 minutes, you're doing whatever you want for 30 minutes, so you're not getting paid for it. As should be obvious if you're clocking out, that this law only applies to non-exempt hourly employees. If you're a salaried employee, this law doesn't apply to you, generally because you get to schedule your own lunch breaks. But okay, what about a situation where you've barely working over 5 hours? Well, California law says if you have a shift that's somewhere between 5 to 6 hours, the employer can ask you to waive that lunch break in writing. Now, you have to sign off in writing, otherwise a violation occurs. Okay, well, where is all this meal break law found? Primarily, it's found in the California wage orders, which are published on the Department of Industrial Relations website. You can just do a quick Google search and you'll find it no problem. And you can find the wage order, and there's like 20 something, that applies to your industry. You can also find it in the California Labor Code, specifically section 226.7. 226.7 outlines what employees care most about, which is the monetary penalties that are incurred when an employer violates this law. But we're going to look at that in just a minute. My office has received hundreds of phone calls from employees complaining about being denied their meal breaks. Really common violations are right here. First and foremost, especially among less sophisticated and smaller employers where they literally have a policy that says you're not allowed to take a lunch break. Well, that's in direct contravention of California employment law. We do see it quite often. More often, we see something like this, where the employer asks the employee, hey, yeah, you can take your lunch, but please work through it. Or yeah, clock out, but please continue working. Very common violation, and we get a lot of phone calls about that. We also get a lot of phone calls where the employer or manager says, yeah, take your lunch break, but can you stay on the premises? Or can you stay, eat your lunch at your desk? If you're a receptionist, can you please stay at the front desk? Just eat your lunch there. Well, that is a violation of law as well, because that's an interrupted lunch break. That's where somebody is still doing job duties, but they're off the clock. That's a violation and a penalty incurs. We also see quite often, especially in the food service industry where people are scheduled for shifts between 5 to 6 hours, that the employer asks them to waive their lunch break, which again is legal, but it has to be done in writing. We see it quite often where the employer doesn't get that waiver in writing. We also see what we call paper policies. Now, this is where the employee handbook and other written policies and procedures say everybody's allowed to take a meal break. You have to take a 30-minute uninterrupted lunch break, but there's actually an unwritten rule at that company that nobody's allowed to take a lunch break, or there's a department where nobody's allowed to take a lunch break, or just a particular manager enforces an unwritten rule that nobody's allowed to take a lunch break. That's very common. We also see a clock out scenario where the employer or a manager just says, hey, yeah, go take your lunch break, but can you run an errand for me? Or hey, can you first answer that email? Or Yeah, clock out, but then make sure you call this guy back. Again, that's asking an employee to work while they're off the clock, and that is a violation of California's meal break law. If your boss or company has forced you to skip your meal breaks, what should you do? California Labor Code Section 226.7 outlines the monetary penalties that employers must pay employees when they force them to skip their meal breaks. Specifically, it says, if you're an hourly employee and you're forced to skip your break, that employer is supposed to pay you 1 hour of pay at your regular rate of pay as a penalty. So let's play out a hypothetical. Let's say you're making $30 an hour and you're a full-time employee, meaning you're working 8 hours a day. And you've worked at this company for 3 years, and every single day your employer forces you to skip your meal break. It happens all the time. And not only that, but you're asked to work through your 30-minute lunch break. So you're not just working 8 hours a day, you're working 8.5 hours a day. What kind of monetary penalties are you owed? Well, you're owed $30 a day as a penalty, and you're owed a half an hour of unpaid overtime violations a day because of that additional 30 minutes. So let's do the math, the basic math. $30 a day times 5 days a week times 52 weeks a year times 3 years. That adds up to $23,400. Okay, let's do the math on the unpaid overtime. A half an hour at an overtime rate of $45 an hour, that's $22.50. Multiply that by 5 days a week, by 52 weeks a year, by 3 years. You've got $17,550 in unpaid overtime violations, all told, just under $41,000. That amount of money will get anybody's attention. Okay, so if you're owed that, how do you go about getting it? Well, there's two main ways. Number one, you can contact the labor board, which we recommend that you do if you've only missed a couple meal breaks or a dozen meal breaks, where your situation is relatively simple. However, if you're owed a sizable amount of money in a scenario like this, where you've missed a lot of meal breaks over the course of a year or two, or you've also got rest break violations, unpaid overtime violations, possibly a wrongful termination, or harassment, or discrimination claim, we highly recommend that you contact a private employment lawyer. Generally, to have a consultation with a private employment lawyer like myself, the consultation is free. And generally, when you hire an employment lawyer, they're working on a contingency fee, which means you're not paying them up front. They're just getting paid out of the settlement at the end of the day. I hope you found this video helpful. Take care.